So we are now on Rule 126, Search and Seizure. I intentionally jumped to Rule 126 because it's best to discuss this right after warrant, no? So let's now start with search and seizure. Section 1, the definition of a search warrant. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property and bring it before the court. In your constitutional law, you will learn that the fundamental right against unlawful searches and seizure is a component of a person's right to privacy. And except for justifiable reasons mentioned by the rules and jurisprudence, kanang search and seizure na i-conduct without a valid warrant is unreasonable and is considered invalid. Unya, as an effect, ang evidence nga makuhaan na in violation of your right against unreasonable search and seizure is considered as inadmissible, meaning dili madawat as evidence in court. But timan-i nga ang Constitution does not prohibit all kinds of searches, okay, and seizure. So timan-i nga as a rule, the Constitution only mandates that a search and seizure must be carried out through or on the strength of a judicial warrant predicated upon the existence of probable cause. In the absence of such warrant, kana nga search and seizure, as what we mentioned earlier, becomes unreasonable, and any evidence nga imong ma-obtain in violation of that would be considered inadmissible. Okay? Now, also remember that search warrant is not a criminal action, nor does it represent a commencement of a criminal prosecution, even if it is entitled like a criminal action. Again, a search warrant is not a criminal action, nor does it represent a commencement of a criminal prosecution, even if it is entitled like a criminal action. It is also not a proceeding against a person, but is solely for the discovery and to get possession of personal property. Okay? It is a special and peculiar remedy, drastic in nature and made necessary because of public necessity. It resembles in some respects with what is commonly known as the John Doe proceedings. Okay? So, to best understand this concept, that search warrant is not a criminal action. It is a special and peculiar remedy. Tanaw na to ang case sa Worldwide Web Corporation or WWC versus the People. This was decided in January 13, 2014. So unsa may nahitabo aning kasuha, Police Chief Inspector Napoleon Villegas of the Regional Intelligence Special Operations Office or RISO of the Philippine National Police filed applications for warrants before the RTC of Quezon City, Branch 78, to search the office premises of the petitioner Worldwide Web Corporation or WWC, located at the 11th floor IBM Plaza Building, number 188 Eastwood City, Libis, Quezon City, as well as the office premises of petitioner Planet Internet Corporation or Planet Internet for brevity, located at UN 2103, 21 or 21st floor at the Orient Square Building, Emerald Avenue, Barangay, San Antonio, Pasig City. The applications allege that the petitioners were conducting illegal toll bypass operations, which amounted to the theft and violation of Presidential Decree number 401. This is an act penalizing the unauthorized installation of water, electrical, or telephone connections, the use of tampered water or electrical meters, and other acts to the damage and prejudice of the Philippine Long Distance Telephone Company or PLDT. On September 25, 2001, the trial court conducted a hearing on the applications for search warrants. The applicant and Jose Enrique Rivera and Raymond Gali of the Alternative Calling Pattern Detection Division of PLDT testified as witnesses. So, nag-testify sila pag-apply nila sa search warrant. According to Rivera, katong um, officer sa Alternative Calling Pattern Detection Division sa PLDT, ingon siya, a legitimate international long distance call should pass through the local exchange or public switch telephone network or PSTN on the toll center of one of the international gateway facilities in the Philippines. The call is then transmitted to the other country through voice circuits, either via fiber optic submarine cable or microwave radio using satellite facilities, and passes the toll center of one of the IGFs in the destination country. The toll center will then meter the call, which will pass through the PSTN of the code number to complete the circuit. In contrast, ingon siya, ang petitioners, ang WWC kuno, were able to provide international long-distance call services to any part of the world by using PLDT's telephone lines but bypassing its IGF. This scheme constitutes toll bypass, a method of routing and completing international long-distance calls using lines, cables, antenna, and wave or frequency which connects directly to the local or domestic exchange facilities of the originating country or the country where the call is originated. On the other hand, Sigale, also an officer of the PLDT, claimed that a phone number serviced by PLDT and registered to WWC was used to provide a service called Global Talk, an internet-based international call service which can be availed of via prepaid or billed postpaid accounts. During a test call using Global Talk, Gali dialed the local PLDT telephone number 6891135, the given access line. After voice prompt required him to enter the user code and personal identification number provided under a Global Talk prepaid account, he was then requested to enter the destination number, which included a country code, the phone number, and a pound sign. The call was completed to a phone number in Taiwan. However, ingon Sigali, when he checked the records, it showed that the call was only directed to the local number 6891135. This indicated that the international test call using Global Talk bypassed again kuno PLDT's IGF. So itong IGF, it's an international gateway facility. Based on the records of PLDT, telephone number 6891135 is registered to the World Wide Web Corporation with address at UN 2103, as what we mentioned earlier. However, upon an ocular inspection conducted by Rivera on its address, it was found that the occupant of the unit is Planet Internet, which also uses the telephone lines registered to WWC. And these telephone lines are interconnected to a server and use as dial-up access lines numbers of WWC. Gale further alleged that because of the because PLDT lines and equipment had been illegally connected by petitioners to a piece of equipment that routed the international calls and bypassed PLDT's IGF, they violated PD number 401 as amended on unauthorized installation of telephone connections. Petitioners also committed theft because through their misuse, through their misuse of PLDT phone lines or numbers and equipment, and with their clear intent of gain, they illegally stole business and revenues that rightly belong to PLDT. Moreover, they acted contrary to the letter and intent of the Republic Act number 7925 because in bypassing the IGF of PLDT, they evaded the payment of access and bypass charges in its favor while piggybacking on its multi-million-dollar facilities and infrastructure, thus stealing its business revenues from international long-distance calls. Further, petitioners acted in gross violation of Memorandum Circular Number 6292 of the National Telecommunications Commission, prohibiting the use of customs premises equipment without first securing type approval license from the latter. Okay? Unya, based on a 5-day sampling of the phone line of the petitioners, PLDT computed a monthly revenue loss of 764,718.08 cents. PLDT likewise alleged that the petitioners, the WWC and Katong Planet Internet, deprived it of foreign exchange revenues and evaded the payment of taxes, license fees, and charges to the prejudice of the government. During the hearing, the trial court required the identification of the office premises or units to be searched, as well as their floor plans showing the location of particular computers and service that would be taken. On September 26, 2001, the RTC granted the application for search warrants. Accordingly, the following warrants were issued against the office premises of the petitioners, authorizing police officers to seize various items. Una, search warrant number Q013856 issued for violation of paragraph 1 of Article 308. This was issued against WWC, Adriel Mirto, Kevin Tan, Cheryl Yu, Carmelo Canto, Ferdinand Mase, etc. etc. Nya mao ni ang mga kaunon, computers, mga softwares. Nya another search warrant was issued number Q-013851 against Planet, this time against Planet Internet. Mao ni ang mga kwaon, modems or routers, mga computers. And then, kaning mga lines, cables, multipliers, etc., etc. And then another search warrant, number Q013858, issued against, again, the Planet Internet Corporation, mga modems, mga computers, lines, and cables, mga multipliers, same atong kaganiha. The warrants were implemented on the same day by RISO operatives of the National Capital Region Police Office. Over 100 items were seized, including 15 central processing units or CPUs, and then 10 monitors, numerous wires, cables, diskettes, and files, o supamang diskettes sa una, and a laptop computer. Planet Internet notes that even personal diskettes of its employees were confiscated, and areas not devoted to the transmission of international calls, such as the president's office and the information desk, were also searched. Voltage regulators, as well as reserve and broken computers, were also searched. Ningon ng petitioners WWC and Cheryl Yu and the Planet Internet that or these petitioners actually filed their respective motions to quash the search warrant. So if you want not to have the search warrant nullified, your option actually is to file a motion to quash. So they filed a motion to quash the search warrant, citing basically the same grounds nga. The search warrants were issued without probable cause since the acts complained of did not constitute theft. Toll bypass, the act complained of, was not a crime. The search warrants were general warrants, and the objects seized pursuant thereto were fruits of the poisonous tree. So PLDT filed a consolidated opposition to the motions to quash. In the hearing of the motions to quash in October 2001, the test calls alluded to by Gali and his affidavit were shown to have bypassed the IGF of the Eastern Telecommunications Philippines of the Capital Wireless. Planet Internet explained that Eastern and Capwire both provided international direct dialing services, which Planet Internet marketed by virtue of reseller agreement. Planet Internet used PLDT lines for the first phase of the call, but the second phase, it used the IGF of either Eastern or Capwire, yun ang Planet. Planet Internet religiously paid PLDT for its domestic phone bills and Eastern and Capwire for its IGF usage. None of these contentions were refuted by the PLDT. So the RTC granted the motion to quash on the ground that the warrants issued were in the nature of general warrants. Thus, the property seized under the said warrants were ordered released to the petitioner. Gipabalik. Okay? So PLDT moved for the reconsideration, but its motion was denied on the ground that it had failed to get the conformity of the city prosecutor prior to the filing of the motion, as required ko no under Section 5, Rule 110 of the Rules on Criminal Procedure. I don't know if you can still recall this. Okay, we've discussed this. So, ang PLDT ni-apilar sa Court of Appeals. And the Court of Appeals reversed and set aside the assailed RTC resolutions and declared the search warrants valid and effective. Dayon, ang petitioners separately moved for reconsideration of the CA ruling. Among the points raised was that PLDT should have filed a petition for certiorari rather than an appeal when it questioned the RTC resolution before the CA. The appellate court denied the motions for reconsideration. Tanawa ang ilang gi-interpose nga issue nga it should not have been an appeal but a petition for certiorari kung dapat ang gi-file sa PLDT. So Rule 45 petitions were separately filed by the petitioners WWC and Cheryl Yu and Planet Internet to assail the CA decision and resolution. Then, gi-consolidate na sa court ang two petitions. So ang issues here nga relevant lang ani atong subject is whether or not the Court of Appeals erred in giving due course the PLDT's appeal despite the following procedural infirmities. Una, PLDT without the conformity of the public prosecutor, had no personality to question the quashal of the search warrant. Ikaduha, PLDT assailed the quashal orders via an appeal rather than a petition for certiorari under Rule 65 of the Rules of Court. May giingon sa Planet, Internet, and WWC. So what was the ruling of the Supreme Court? Ngayon ng Supreme Court, an application for a search warrant is not a criminal action. Conformity of the public prosecutor is not necessary to give the aggrieved party personality to question an order quashing search warrants. Okay, so na-answer na. Na-answer na ang first issue nga kailangan ba ang conformity sa public prosecutor. So ngayon ng Supreme Court, no, there's no need to secure the conformity of the public prosecutor because an application for a search warrant is not a criminal action. Okay? And petitioners contend that PLDT had no personality to question the quashal of the search warrant without the conformity of the public prosecutor. According to the court, they argued that it violated Section 5, Rule 110, nga nag-ingon nga all criminal actions commenced by complaint or information shall be prosecuted under the direction and control of the prosecutor. Further, ningon ng Supreme Court, the above provision states the general rule that a public prosecutor has direction and control of the prosecution of all criminal actions commenced by complaint or information. However, in the Supreme Court, a search warrant is obtained not by the filing of a complaint or information, but by filing of an application, therefore. Further, as we held in Malaluan versus CA, an application for a search warrant is a special criminal process rather than a criminal action. Tanawa na guys ha, gawas ni before sa bar, na a search warrant, an application for search warrant is a special criminal process rather than a criminal action. And the basic flaw in this reasoning is in erroneously equating the application for an obtention of a search warrant with the institution and prosecution of a criminal action in a trial court. It will thus categorize what is only a special criminal process, the power to issue which is inherent in all courts, as equivalent to a criminal action, jurisdiction over which is reposed in specific courts of indicated competence. It ignores the fact that the requisites, the procedure, and purpose of the issuance of a search warrant are completely different from those for the institution of a criminal action. Okay? So, timan ina ha, again, the application or an application for a search warrant is a special criminal process rather than a criminal action. On the second issue, oh, this is a continuation and continuation. So, for indeed a warrant, such as a warrant of arrest or search warrant, merely constitutes process. A search warrant is defined in our jurisdiction as an order in writing issued in the name of the people of the Philippines, signed by the judge and directed to a peace officer, commanding him to search for personal property and bring it before the court. A search warrant is in the nature of a criminal process akin to a writ of discovery. It is a special and peculiar remedy, drastic in its nature and made necessary because of a public necessity. In American jurisdictions, from which we have taken our jural concept and provisions on search warrants, such warrant is definitively considered merely as a process, okay? Generally issued by a court in the exercise of its ancillary jurisdiction and not a criminal action to be entertained by a court pursuant to its original jurisdiction. We emphasize this fact for purposes of both issues as formulated in this opinion with the catalog of authorities therein. Okay? Clearly, ningon ng Supreme Court, an application for search warrant is not a criminal action. And meanwhile, we have consistently recognized the right of the parties to question orders quashing those warrants. Accordingly, we sustain the CA's ruling that the conformity of the public prosecutor is not necessary before an aggrieved party moves for reconsideration of an order granting a motion to quash search warrants. Now, on the second issue, an order kuno quashing a search warrant which was issued independently prior to the filing of a criminal action partakes of a final order that can be the proper subject of an appeal. Petitioners, according to the Supreme Court, petitioners also claim that since the RTC ruling on the motions to quash was interlocutory, it cannot be appealed under Rule 41 of the Rules of Court. PLDT should have filed a Rule 65 petition instead. Petitioners cite as authority of their position the case of Marcelo versus de Guzman. The court in that case held, according to the Supreme Court, nga but is the order of Judge de Guzman denying the motion to quash the search warrant and to return the property seized thereunder final in character, or is it merely interlocutory? In Cruz versus Dinglasan, this court, citing American jurisprudence, resolved this issue as follows. Where accused in criminal proceeding has petitioned for the return of the goods seized, the order of restoration by inferior court is interlocutory and hence not appealable. Okay, balik. Where an accused in criminal proceeding has petitioned for the return of the goods seized, the order of restoration by the inferior court is interlocutory and hence not appealable. Like a denial by the U.S. District Court of the defendant's petition for the return of the article seized under a warrant is such an interlocutory order. A final order is defined as one which disposes of the whole subject matter or terminates a particular proceeding or action, leaving nothing to be done but to enforce by execution what has been determined. So on the other hand, an order is interlocutory if it does not dispose of a case completely, but leaves something more to be done upon its merits. Tested against this criterion, the search warrant issued in criminal case number 558 is indisputably interlocutory character because it leaves something more to be done in the said case, that is, the determination of the guilt of the accused therein. Petitioner's reliance upon Marcelo is misplaced ngayon ng Supreme Court. An application for a search warrant is a judicial process conducted either as an incident in a main criminal case already filed in court or in anticipation of one yet to be filed. Whether the criminal case of which the search warrant is an incident has already been filed before the trial court is significant for the purpose of determining the proper remedy from a grant or denial of a motion to quash search warrant. I-explain ko lang mayo sa court, ha? So, ngayon ng Supreme Court, where the search warrant is issued as an incident of a pending criminal case, as it was in Marcelo, the quashal of a search warrant is merely interlocutory. Kaya na pa may main action, okay? there is still something in Supreme Court because there's still something more to be done in the said criminal case. That is the determination of the guilt of the accused therein. Now, in contrast, in the Supreme Court, kung ang search warrant is applied for and issued in anticipation of a criminal case yet to be filed, the order quashing the warrant and the denial of the motion for reconsideration of the grant ends the judicial process. And there is nothing more to be done thereafter. So, gidistingo sa Supreme Court. Thus, ningon ng Supreme Court, thus, the CA correctly ruled that Marcelo does not apply to this case. Here, the applications for search warrants were instituted as principal proceedings and not as incidents to pending criminal actions. So when the search warrants issued were subsequently quashed by the RTC, there was nothing left to be done by the trial court. Thus, the quashal of the search warrants were final order, not interlocutory, and an appeal may be properly taken therefrom. Okay, so tanawan ninyo ang distinction ha. Kung final na ang order sa quashal, meaning walay main action nga nagdepend ba ang issuance sa imong search warrant, ang appeal, ang remedy on appeal is actually available. It is proper, okay? But if the denial or the quashal is merely interlocutory, okay, interlocutory and decision on a particular motion, so the available remedy is kato petition for certiorari. So just take note of that. And also take note of the concept that an application for a search warrant is a special criminal or a special criminal process and not a criminal action. Okay? Also remember that the rule against unreasonable searches and seizure is a protection against governmental intrusion. So the rule against unreasonable searches and seizure does not extend to acts committed by private individuals and entities, okay? If you study your Bill of Rights, you will notice that the enumeration of these rights are actually protection against government violations, okay, or against governmental violations. So here it also follows that when there is a violation of our right against unreasonable search and seizure, it only extends to governmental intrusions and not the intrusions committed by private individuals and entities, okay? This rule is illustrated in one case in which the inspection team of an electric company conducted a routine inspection of several houses to check on illegal connections, meter tampering, seals, conduit, pipes, jumpers, wiring connections, and meter installations. One of the houses inspected was that of the plaintiff, who claimed that there was nothing routine or proper at all with what the inspection team did. The team, it was alleged, entered his house and the surrounding premises without his permission and over the objection of his maids. The members of the team threatened, forced, or coerced their way into the house. And the plaintiff's main argument here consisted on alleged violation of inspection team of his constitutional right against unreasonable searches and seizure. The Supreme Court here did not agree with the posturings of the plaintiff. Ningon ng Supreme Court nga the constitutional guarantee against unlawful searches and seizure is intended as a restraint against the government and its agents tasked with law enforcement. It is to be invoked only to ensure freedom from arbitrary and unreasonable exercise of state power. Also note that the constitutional prescription against unlawful searches and seizure could not or could only be invoked against a state to whom the restraint against arbitrary and unreasonable exercise of power is imposed. In an early case, the accused sent packages destined for abroad through a private forwarding and shipping company. And following standard operating procedures, an employee of the company opened the packages because of the peculiar odor they emitted. So he found dried marijuana leaves inside the packages and reported the matter to the NBI. The NBI took custody of the packages and charged the accused, who was found guilty of violating the drug law. On appeal, the accused moved for the suppression of the evidence as the fruit of an unreasonable search and seizure. Also on appeal, the court held that the NBI agents made no search and seizure, much less an illegal one, contrary to the postulate of the accused appellant. The packages were opened by a private individual and not by the agents, and their mere presence after the contraband was discovered did not convert the search effective by a private employee into a warrantless search and seizure by government agents. Merely to observe and look at that which is in plain sight is not a search. Having observed that which already have been opened, where no trespass have been committed in aid thereof, is not an illegal search. And the Supreme Court further said that the Bill of Rights embodied in the Constitution is not meant to be invoked against acts of private individuals. The Constitution prescription against unlawful searches and seizure applies as a restraint directed only against the government and its agencies tasked with the enforcement of the law. Thus, it could only be invoked against the state to whom the restraint against arbitrary and unreasonable exercise of power is imposed. And the court further elucidates that if a search is made upon the request of law enforcers, a warrant must generally be first secured if it is to pass the test of constitutionality. However, if the search is made at the behest or initiative of the proprietor of a private establishment for its own and private purposes, as in the case at bar, and without the intervention of police authorities, the right against unreasonable search and seizure cannot be invoked, for only the act of private individual, not the law enforcer, is invoked. In sum, the protection against unreasonable searches and seizures cannot be extended to acts committed by private individuals as to bring it within the ambit of alleged unlawful intrusion by the government. Okay? Okay, now, how do we distinguish search and seizure from arrest? Okay, so these are the distinctions. So, first distinction, the issuance of a warrant of arrest presupposes the existence of a pending criminal case that gave rise to the warrant. A search warrant, on one hand, does not require the existence of a criminal case. It may be issued prior to the filing of the case. Okay. Second, the rules on arrest are concerned with the seizure of a person so he may be made to answer for the commission of an offense. It involves the taking of a person into custody. A search, on one hand, is concerned with the seizure of personal property subject to the offense, the stolen or embezzled property, the fruits of the offense, or those intended to be used for the offense. Another thing is that a probable cause to arrest does not necessarily involve a probable cause to search and vice versa. Probable cause to arrest involves a different determination from probable cause to search. In order to determine probable cause to arrest, the judge, not the prosecutor, must have sufficient facts in his hands that would tend to show that a crime has been committed and that a particular person committed it. Probable cause to search requires facts to show that particular things connected with the crime are found in a specific location. Then an arrest the warrant may be made on any day and at any time of the day. A search warrant on one hand is generally served in any day unless there is a direction in the warrant that it may be served at any time of the day or night. The rule on arrest do not provide for limitation on the duration of the validity of the arrest, but in contrast, ang Section 10 of Rule 126 provides for a search warrant that or provides that a search warrant shall only be valid for 10 days from its date and thereafter it shall be void. Right? Now on to Section 2, court where the application for search warrant shall be filed. So according to this, an application for search warrant shall be filed with the following: any court within whose territorial jurisdiction a crime was committed for compelling reasons stated in the application, any court within the judicial region where the crime was committed of the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. However, if the criminal action has already been filed,
the application shall only be made in the court where the trial or the criminal action is pending. Now remember, in this section, particularly in section B, this provides for the exceptions, no, wherein you can actually file for an application for a search warrant not in the place or territorial jurisdiction where the crime was committed, but in any other place. The rule on the statement requiring the compelling reasons is a mandatory nature, okay? In one case, ningon ng Supreme Court, the inclusion of a statement of compelling reason in a search warrant application that is filed in a court which does not have jurisdiction over the place of the commission of the offense is a mandatory requirement, and the absence of such statement renders the application defective. However, However, in the Supreme Court, the statement of compelling reasons is not a ground for the outright denial of the search warrant application, since it is not one of the requirements for the issuance of a search warrant. In other words, the statement of compelling reasons is only a mandatory requirement insofar as the proper venue for the filing of the search warrant application is concerned. It cannot be viewed as an additional requisite for the issuance of a search warrant. Okay? Now let's go to search warrants involving heinous crimes
and other crimes. The rule provided for in Section 2 in the previous slide have been deemed modified by Administrative Matter number 99-20-09-SC dated January 2000 in cases involving heinous crimes, illegal gambling, dangerous drugs, and illegal possession of firearms. Under the aforementioned issuance of the Supreme Court, the executive judges and vice executive judges of the RTC of Manila and Quezon City are authorized to act on all applications for search warrants involving any of the above crimes filed by the PNP, the NBI, the PAOK-TF, and the REACT-TF. The application shall be personally endorsed by the heads of said offices for the search of places to be particularly described therein and the seizure of the property or things as prescribed in the rules of court. The warrants issued may be served in places outside the territorial jurisdiction of the said courts. The authorized judges shall keep a special docket book listing the details of the applications and the results of the searches and seizures made pursuant to the warrants issued. Okay? Now, unsa may mga properties nga i-seized if there is already a search warrant issued? So, mo ni sila. A search warrant may be issued for the search and seizure of personal property, including subject of the offense, stolen or embezzled, and other proceeds or fruits of the offense, or used or intended to be used as the means of committing an offense. Okay? The rule is only personal properties described in the search warrant may be seized by the authorities. Okay? If you notice, ganiha sa katong case sa WWC versus people, specific kaayo ang mga properties na kailangan kwaon sa authorities, no? I-enumerate yun na siya sa search warrant. That is why, remember that only those personal properties nga gi-describe sa search warrant ang pwede rang i-seize sa mga authorities, okay? In one case, in People versus Nunez, this is actually stated in your book, ang search warrant number 42 specifically authorized the taking of methamphetamine hydrochloride or shabu and paraphernalia only. Okay? So by the principle of justem generis, you have actually learned this in your StatCon, diba? Statutory construction. With the principle of justem generis, the court explained that where a statute describes things of a particular class or kind accompanied by words of generic character, the generic word will usually be limited to the things of a similar nature with those particularly enumerated, unless there be something in the context of the statement which would repel such inference. Meaning, kung mayroon ka og methamphetamine hydrochloride, shabu, niya followed by and paraphernalia only, it only pertains to the paraphernalia that will be used in consuming the shabu, diba? So, ngayon ng Supreme Court, certainly, the lady's wallet, the lady's wallet, the cash, the grinder, camera, components, speakers, mga electric planner, jigsaw. These are already, or these were not encompassed by the word paraphernalia, as they bear no relation to the use of manufacture of drugs, okay? Magamit day na ang speaker sa pag-manufacture of drugs. So, ngayon ang Supreme Court, in seizing the said items, then, the police officers exercise their own discretion and determine for themselves which items in appellant's residence they believe were proceeds of the crime or means of committing the offense. And this, according to the Supreme Court, is absolutely impermissible. Okay? In the same case, the court declared that the purpose of the constitutional requirement that the articles to be seized be particularly described in the warrant is to limit the things to those and only those particularly described in the search warrant. And of course, leave the officers of the law with no discretion regarding what articles they should seize, okay? A search warrant is not a sweeping authority empowering a raiding party to undertake a fishing expedition to confiscate any and all kinds of evidence or articles relating to a crime. Accordingly, on the Supreme Court, the objects taken which were not specified in the search warrant should be restored to the appellant, okay? Now, what are the requisites for issuing a search warrant? So, Section 4 provides that a search warrant shall not issue except upon probable cause in connection with one specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the things to be seized, which may be anywhere in the Philippines. Ganahan kay ko ani nga provision, okay? So, klaro kay na ha, nga the validity of a search warrant rests on the factors provided for in Section 4. Okay? Unsa man na, nga it must be issued upon probable cause, and the probable cause must be determined by the judge himself and not by the applicant or any other person. And in the determination of probable cause, the judge must examine under oath or affirmation the complainant and such witnesses he may produce. The warrant issued must particularly describe the place to be searched and persons or things to be seized. Okay? The absence of the requisites for a search warrant's validity will cause its downright nullification. So, pwede dahil na nimo filean og motion to quash. Okay? In the case of Dimal versus People, ngayon na Supreme Court, nga in an application for search warrant, the mandate of the judge is for him to conduct a full and searching examination of the complainant and the witnesses he may produce. Okay? The searching questions propounded to the applicant and the witnesses must depend on a large extent upon the discretion of the judge. And although there is no hard and fast rule as to how a judge may conduct his examination, it is axiomatic that the said examination must be probing and exhaustive and not merely routinary, general, peripheral, or perfunctory. Okay? He must make his own inquiry on the intent and factual and legal justifications for a search warrant. The questions should not be merely repetitious of the averment stated in the affidavits or deposition of the applicant and the witnesses. Okay. Also note the long-standing rule is that a description of a place to be searched is sufficient if the officer with the warrant can, with reasonable effort, ascertain and identify the place intended and distinguish it from other places in the community. And any designation or description that points out the place to the exclusion of all others and an inquiry leads the officers unerringly to it satisfies the constitutional requirement. Okay. What else? Okay. Also remember nga, ownership is of no consequence when it comes to the issuance of a search warrant, okay? The law does not require that the property to be searched or to be seized should be owned by the person against whom the search warrant is directed. It is sufficient that the person against whom the warrant is directed has control and possession of the property sought to be seized, okay? That's what the Supreme Court said in the case of Yao versus People. Okay. Now, aside from the requirements mandated by Section 4 of Rule 126, the rule also requires the judge to comply with specific procedure in the conduct of examination of the complainant and the witnesses he may produce. And the required procedure involves the following. Kanina sa Section 5, examination must be personally conducted by the judge. The examination must be in the form of searching questions and answers. The complainant and the witnesses shall be examined on those facts personally known to them. The statements must be in writing and under oath, and the sworn statements of the complainant and the witnesses, together with the affidavit submitted, shall be attached to the records. Okay? So, timan nga the facts and circumstances to be testified to by the complainant and the witnesses he may produce being referred thereto pertain to facts, data, or information personally known to them. Okay? And di pwede nga chika-chika or minaritesra. It has to be of personal knowledge. Okay? This is because the purpose of the same is to convince the judge of the existence of probable cause and to ensure that search warrants are not issued on loose, vague, or doubtful basis of fact, and also not on mere suspicion and belief. Okay? Ooh, na. Okay, now let's just browse through this one. Issue once and form a search warrant. Section 6 provides that if the judge is satisfied of the existence of facts upon which the application is based, or that there is probable cause to believe that they exist, he shall issue the warrant, which must be substantially in the form prescribed by these rules. Okay, that's self-explanatory. And then Section 7, the officer has actually the right to break into a door and window to effect a search. Okay, so the officer, this is allowed if the officer is refused admittance to the place of directed search after giving notice of his purpose and authority, may break open any outer any door or window of a house or any part of a house or anything therein to execute the warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. Okay. Also, no search of a house, room, or any other premises shall be made except in the presence of the lawful occupant thereof or any member of his family, or in the absence of the latter, two witnesses of sufficient age and discretion residing in the same locality. Na may mga police diri aning klasihan, no? You have experience before kanang serving a search warrant. So kung walay lawful occupant, what you do is inyong magkuha mo og mga konsehal sa barangay, di ba, to witness the service of the search warrant. So, di man nga kung walay lawful occupants or any member of his family, what you do is to ensure the presence of at least two witnesses of sufficient age and discretion. The rule here is very clear, that no search shall be made except in the presence of persons mentioned in this section. Okay? Okay, time of making search. Ato nang gisgutan ganiha when we distinguish it, no, from the warrant of arrest, that the warrant must direct that it be served in the daytime. Daytime gina. Unless the affidavit asserts that the property is on the person or on the place ordered to be searched, is, or in which case a direction may be inserted that it be served at any time of the day or night. Okay. So as a general rule, the warrant shall be served in daytime and such fact must be directed in the warrant. However, if the affidavit of the applicants asserts that the property is on the person or in the place ordered to be searched, the warrant may insert a direction that it may be served at any time of the day or night. And the rule on issuance of search warrant allows for the exercise of judicial discretion in fixing the time, which or within which the warrant may be served, subject, of course, to the statutory requirement fixing the maximum time for the execution of the search warrant. Now, pila man kaadlaw nga ang usa ka search warrant valid. Unlike sa warrant of arrest nga way expiration, ang search warrant shall be valid only for 10 days from its date. And thereafter, considered na siya nga void. Okay, so that's basically one of the distinctions. And then, what happens if you receive the property seized? So the officer seizing property under warrant must give a detailed receipt for the same to the lawful occupant of the premises, in whose presence the search and seizure were made, or in the absence of such occupant, must, in the presence of at least two witnesses of sufficient age and discretion residing in the same locality, leave a receipt in the place in which he found the seized property. That's self-explanatory. Okay. Okay. Here in section 12, this only reiterates that a judge should know that his duty as a magistrate does not end when the warrant is issued. So when the evidence shows that the judge who issued the search warrant did not require the officers executing the warrant to make an accurate and complete inventory of the things seized and submit the same to him, he is guilty of gross ignorance of the law. So once na-deliver na ang property, there has to be an inventory to the court and return and proceedings thereon. Okay, so just read section 12. Okay, so kaning section 13 and 14, we will discuss this on the next meeting. Okay, so I will be posting your quiz for you to answer in a bit. Thank you.